Now back to Inside Real Estate. Here's Mike the Realtor.
How we doing, folks? We are back. InsideRealEstateRadio.com is the website. InsideRealEstateRadio.com is the website. Time to get into a little bit of legal specialization talk with our legal expert, resident expert in all things legal, Perry Cockerell. His website, perryjcockerell.com, perryjcockerell.com. And I've got some great news, by the way. As you know, he is the author of A Private War, which is available in the single edition as well as the multiple editions. You can go to Amazon for that. But good news, the new sequel is coming out. A Private War 2 is coming out soon. And so congratulations on that. Perry, what's up?
Thanks, Mike, and I appreciate being here today. I wanted to talk about this doctrine of what they call innocent purchaser doctrine. That's when you buy a piece of property, you usually rely on your title insurance company, your title company that examines the title for you, and you assume you're buying it free of any claim of somebody else.
Right.
You don't even think about that.
Right.
It might be a good time for people to start considering looking at exactly where this property's coming from and who actually bought it in the past. Mm-hmm. Because it's a real serious problem right now. There's apparently over 100 lawsuits going on that involve properties that have been acquired. And in the chain of title, there's been a judgment from a court adjudicating title or invalidating a lien, something of that nature. And then the property is being sold down the line. And then these judgments are being overturned. The party to them have gone back to court and have overturned these judgments, and the property's already been sold down the road. And in those cases, you can lose your home because those kinds of the conveyance that involve a judgment, if that judgment's void, then you can lose the property down the road. Mm-hmm. But let me give you a little history of it, of kind of this area, but it kind of goes back to 1942 when there was a case went to the Supreme Court, and it involved someone who had defaulted on their mortgage on their home, and the substitute trustee sold the property at the foreclosure sale, and then it was transferred 3 times later after that. Now, there was nothing in the chain of title that indicated that foreclosure was conducted improperly. It doesn't recite that the debt was not in default or was in default. It didn't indicate. So when they examined the title, it looks clear. It's been transferred 3 times. The Supreme Court held that in that case, that as it turned out, the note was not in default. The substitute trustee actually didn't conduct the sale. Somebody else did. But the property had been sold 3 times down the road, and there had been lenders who'd already loaned on that.
Sure.
And the Supreme Court held, no, that sale is void, but it's void between the property owner and the lender. But since it was sold down the line, those people who purchased, the deed was voidable as to them because they acquired good title by execution, by the owner who executed that deed of trust. He created the appearance of good title, and it would be inequitable to prevent the owner to show otherwise to someone who purchased in good faith. And as you can see, those parties purchased in good faith because they could not determine that substitute trustee's deed in any way appeared to be void.
Right.
Now, that concept since 1942, everybody calls it the subsequent purchaser defense. Now, 2013, that subsequent purchaser defense was challenged as well as the innocent purchaser defense. Now, the innocent purchaser is when you buy a piece of property and it turns out maybe somebody else has a deed to the same property. And I've had that very same thing where the owner sold the property twice to 2 different people.
Wow.
The one who wins is the one that is a filed of record. The document's proved, it's filed of record.
Right.
And that's what the innocent purchaser doctrine is designed to do, is to protect you from unrecorded interests in the property. And then the subsequent purchaser, as we mentioned, would protect you in case of an improper foreclosure down within the chain of title. Now, here comes this new case from the Supreme Court. It's really 4 years old, and that involved a judgment where the state of Texas obtained a right-of-way for a drainage easement. But in the final judgment, they actually acquired title to the entire property. Now, a year later, the parties realize, wait a minute, that's not what we actually intended.
Mm-hmm.
So they go and they amend the judgment to correct it, so to speak, so that it's only an easement, which is probably what was originally intended.
What was the deal, right?
However, that's not what the first judgment said. And in that case, you cannot take an amended judgment and call it a judgment done pro tunc and change the substance of the first judgment. And so after they obtained the second judgment, the property owner sold the 10 acres. Now, the state of Texas comes in and the parties the new owner gets in a dispute with the state of Texas, who contends, no, we have title to the whole thing. Mm-hmm. And you have two judgments of record, and the second one is void. Now, you see the difference in the first case? You have a deed of the foreclosure that you cannot tell on the face of that deed.
Right.
There's anything wrong.
Anything wrong with it, yeah.
Now, but you're buying, in this case, with two judgments of record, whoever's examining the title has got to be very good and examine that second judgment to determine what is it doing. If it's substantially changing the first judgment, that's a void judgment. And that's what happened. That second judgment was void. Mm-hmm. So in that case, you're not really a bona fide purchaser, or you're not really a subsequent purchaser purchasing in a way that would make it inequitable, because the error in that case is not caused by the party transferring.
Because you can see it up front. You should be able to see it up front.
This requires an attorney, title examiner, to examine both. So that's so you can lose your title because a judgment is of record and you take knowledge of it.
But if it wasn't caught, so like the purchaser it may not be something obvious. It would be something that the title examiner would be the one to uncover that.
That's exactly right. And you're relying on the title company to examine this title, because if this title fails, title insurance policy is going to pay you the policy limits. But if you have a loan against that property, the money's going to go to the lend holder, and you'll get nothing.
Right.
And you might put $50,000 to $60,000 of improvements in that property and be faced with. So I've had situations like that where the property owner buys with there being a judgment. The disclosure sale, when you buy a piece of property, the seller is required to give a disclosure, and it will ask, are you aware of any litigation? And it might say yes or it might no. What you might ask is, are you aware of any litigation by the seller involving the title to the property itself? And if that title has a judgment in it, adjudicating title, you really better check that out carefully, because you're bound by it, even though the examination is done by the title company. That examination is done for the title company's purpose. Right. The property owner typically doesn't even look at the chain of title.
Right. Well, and the title examiner, it's not like we ever really talk to the title examiner. They are behind the scenes people. As far as the title company is concerned, we talk to, the escrow officer, and, we don't really talk to the title examiners and the title attorneys that are behind the scenes. So, yeah, you've got to. It just goes to the point of making sure that you know who you're going to be using and that they're reputable.
The other concern I want to mention is if you have to watch out for homeowners associations that are foreclosing on these liens. Yes. They are foreclosing and sometimes not notifying the superior lien holder. And then some entity will buy this property and question whether there's a lien on it. And they might file a lawsuit against the superior lien holder, challenging their lien. And then for some reason or another, the lien holder doesn't answer the lawsuit. And then they get a default judgment that invalidates that lien. And then the property is transferred 2 or 3 times down the road, kind of like because they realize there's this subsequent purchaser defense. It goes back to 1942. However, if that default judgment itself is overturned, then they can argue this other case applies and you're just not an innocent purchaser. So if you have a default judgment of record, you really have to look at that default judgment and make certain, because that default judgment could be overturned within 4 years. But if the party who sued has never been served at all with the lawsuit or is properly served, they can come back at any time and set that judgment aside. It's not limited by the 4-year rule. And so there's apparently there's lots of lawsuits around the state involving judgments of record, default judgments in your chains. Now the owner needs to be really cautious and might want to ask that question.
Yeah. And it's a big takeaway here, buyers, looking for real estate out there, between you and your agent and the title company, you've got to make sure, ask questions. Is there any litigation going on related to the property in any way, shape, form, or fashion, or any pending litigation? The husband and wife, something going on there, divorce potential, some of those types of things. Or is there something going on within the family as far as ownership of the property and or properties, estate, et cetera, et cetera. So pay attention to that, folks out there. That's good stuff, Perry.
Thank you.
Hey, his website, perryjcockerell.com, perryjcockerell.com. And don't forget A Private War and A Private War 2 coming out soon. Folks, we're going to take a short break. See you in a few.